We have some people, I see numbers, excellent numbers going up. That is a good sign. If you are logged in today to learn about trust, you are definitely in the right place. I am Dan Hershkowitz. I am a volunteer at SFAR, a board member, former president of our association. And we are here today with John O'Grady and Diane Duvall, attorneys who are going to teach us lots. It is going to be my pleasure to introduce John, someone that I've known for a while, and John will give us an introduction to his co-brilliant lawyer, Diane. So let me tell you a little bit about John. So John has made it so it's not easy to talk about death, wills, trusts, terminal illness, loss, conflicts about family, money, elder care, but that's what John does. As an estate mediator and estate planning lawyer, John's legacy, frankly, is alive every time he guides his clients to resolve their conflicts so that they stay connected, because this is the opportunity to disconnect, right? And yet his focus in law, believe it or not, is connection and planning. John is direct, non-judgmental, and all the time, all the while, frankly, empathetic. His persistent, calm demeanor is the foundation for his success, and since 1989, John has successfully guided clients in mediating disputes. Seemingly insurmountable conflicts come to resolution as a direct result of his attentive listening and thoughtful questions. And blue hair today, John, look at you. John is an attorney, leads a full-service estate planning practice in San Francisco. He was the 2012 chair of the Estate Planning, Trust, and Probate section of the Bar Association of San Francisco. If you would like to learn more about John O'Grady, you can find him on the interweb, www.o'gradylaw.com. O'gradylaw.com. It's that simple. John, thank you so much for being here today.
Thank you for your kind introduction, Dan.
Pleasure.
It's true. One of my claims to fame is I'm the only blue-haired lawyer in town. And Diane Duvall is a longtime mediator with a demonstrated success in helping people talk to each other, which is kind of what we do together. And today, Diane will be in more of an observer role, and I'm delighted to be here with you all, and I'm anxious to get started.
Good. Let me give a little housekeeping. So we are flexible here. John and I both enjoy your participation. We have 77 people on the call so far. And if you have a burning question, we certainly wouldn't mind you speaking up and saying, I have something. We really don't. You could raise your hand or you could speak up. I have a feeling, however, most of your questions will be answered, and we're going to do our best to do that in the next hour. The presentation that we have has a bunch of slides, and at the end of these slides, after we discuss what a trust is and what the different trusts are and who the players are and how it works and give you some good advice, at the end, we have some slides regarding you as a realtor, right? The representative capacity signature form, the listing agreement, who needs to sign, and disclosure exemptions. But what I'd like to do, frankly, is in case we get so enthralled with what we're doing, we never get there, I'm going to flip the order, and I'm going to take the first 5 minutes, and we're going to go towards the end of the slides, and we're just going to talk for a moment about some of the nuts and bolts having to do with trusts and the representative capacity and the disclosures. So if you would indulge me, that's where we're going to start, okay? So we're all familiar with the representative capacity signature disclosure form, right? The RCSD. It basically says this. It says that, hey, me, Dan Hershkowitz, I'm not signing today as an individual, but I'm really signing in another capacity. And for a trust, it's in my capacity as a trustee. So if and when you want to sue me for breach of contract or whatever you want to sue me for, you're really not suing the personal Dan, you're suing the trustee Dan. This is more obvious with different relationships. You'll see that a trust, John will explain, is more of a relationship than an entity. But if you were instead, for instance, it was Dan, the managing the managing partner of an LLC, that makes it much more clear. Or Dan Hershkowitz, executive vice president of the McDonald's Corporation. or Dan Hershkowitz, attorney in fact for some other person, a principal. You could see how the representative capacity signature form is important, right? In the trust context, where we often go wrong with the representative capacity signature disclosure is we forget that the trust needs to exist at the time we are in fact signing this form. This form is saying that I am already in this position. Our contract, the car contract and the San Francisco contract, allow for the assignment from an individual, like me and my wife as buyers, into our own family trust. For instance, the Hershkowitz Family Trust dated 2022, or an LLC that we form. But it has to exist at the time we sign this representative capacity signature disclosure. It's affirming that the trust already exists. So make sure that you actually have trust documents, and you also need to confirm that the person who is signing is the right person. Often we rely on the escrow officer and their title department to help us with that. We ask our clients to show us their trust documents, or we'll see that the title is already taken or held in trust. And then we need to confirm that we have the right trustees signing. Sometimes there's more than one. And as John will tell us, sometimes one can sign, sometimes both need to sign. And sometimes we have a trustee who was not an original trustee, who was named as a quote unquote off the bench replacement trustee. And we'll see that we have special wording for that as well. Okay, those are our reminders regarding the representative capacity signature disclosure. I like to, when I take a listing agreement, you would certainly be attaching it, but what I like to do is I like to, in additional terms, have the owner just confirm that the owner of record per the attached whatever public records shows the 1998 Smith Family Trust. Clarence Smith represents, he is the trustee with the power to sign on behalf of the 1998 Smith Family Trust, and will provide the necessary trust documents within 3 days. See the attached RCSD. I like to use some plain language like that. Some agents like the concept that it takes 1 to list and 2 to sell. I hate that idea. If you are representing a seller, you need everyone who needs to sign to transfer the property to sign your listing agreement. Okay, so if there are spouses, we want both. If there are 2 trustees, we need both. Okay, all right. And then what about disclosures, finally? So is there an exemption for a trust? And so section 1102 of their civil code talks about who needs to disclose what. It establishes the transfer disclosure statement, and it also establishes some exemptions for us. And we'll see that we have exemptions for trusts, so that's great. But there's a form, the trust advisory that CAR puts out for us, that reminds us, yes, there are some exemptions, but there are also many disclosure requirements. And that form starts by explaining that whomever the seller is, whether it's someone selling in a capacity as a trust or attorney in fact, a corporate representative, whoever it might be, they always have to disclose all known material facts. And then the next question is this trust otherwise exempt? And it starts with the concept that trusts are exempt. And if the trust is irrevocable, and John will tell us more later about revocable versus irrevocable trust. If the trust is irrevocable, then in fact, you are always exempt from the transfer disclosure statement at all. That does not exempt the seller from disclosing known material facts, but they don't have to fill out the form, okay? And as a result, there's no rescission right for the buyer based on receiving and approving that form, okay? But what if it's a revocable trust? Well, if it's a revocable trust, which most family trusts are, like the 2022 Hershkowitz Family Trust, most of them are revocable. They can be withdrawn, they can be amended, they can be changed. John will show us that in a little while. If it is a revocable trust, we start with the concept that it is exempt, but we then have to ask 2 questions. Are any of the trustees, and in this case, it would be Dan Hershkowitz and my wife, Elisa, are any of the trustees persons who were previously on title as owners? So if Elisa and I bought this in our own names and then transferred it into our trust, that kills the exemption, and we now have to fill out the transfer disclosure statement. Or The second question we must ask is, have any of these trustees lived at the property in the last 12 months? And if the answer is yes, then that trustee has to fill out the transfer disclosure statement. All of this is set forth in that trust advisory form that CAR has. I put it out there so that you understand. One last concept. Often we have a trust that is exempt, but some family member has been living at the house, perhaps paying small rent, whatever it might be, for years and years. Or there's a property management company that's been managing the property, and they're communicating with the trustee who's overseeing this. In that instance, it's very possible that the trustee will have substantial material information. So we need to always make sure that that material information, those material facts, are disclosed. Okay. All right. We did it, John. We got the boring realtor stuff out of the way. Why don't you jump us into the slides and we'll do the exciting stuff.
Great. And before I get to the slides, actually, there's several kind of add-ons I have, Dan.
Please.
Yeah, like, and this is really important, that a trustee cannot delegate their duties. They can get assistance. They can hire a lawyer or a realtor or anybody else, but they have to supervise everybody and be responsible for everybody. And as a lawyer, you know, I'm responsible for making sure my client does their job right, or at least gets good advice about how to do it. And so part of it is like, how do you work with a realtor? And, you know, so I have several kind of things I always kind of tell my clients about how to work with the realtor. And here they are.
Great.
Yeah. One is, you know, don't sign a listing agreement for more than 90 days. There's no need for it. It can be renegotiated like on the 80th day if you need to, right? One is, you don't pay compensation of more than 5% on a property more than 500, worth more than 500,000. Because there's plenty of realtors who will do it for 5%. Anyway, and don't.
John, so far this group hates you, just so you know.
Yeah. Okay. Well, yeah. Well, I've been thrown off that bridge behind you. I've been shot at. I've been butchered. Yeah. So lots of people hate lawyers.
Good point.
Especially the client when they get a bill. So I'm used to it. Okay. And I don't like dual representation at all. Like most of us lawyers don't, because we would never think of representing a buyer and a seller in any kind of deal. It would violate our ethics all over the place. And it would make it hard to know who the client's really loyal to, who the realtor is really loyal to.
And John, just for this group, I will remind this group that when we think of dual agency, and I think the way John is referring it to now is he's thinking about one agent representing both sides. As we all know in this group, dual agency is a misnomer. It really should be called dual brokerage, because when your brokerage is on both sides, you're technically a dual agent and you need consent, right? And there's disclosure. But I have a feeling, John, that you're okay with the concept of Coldwell Banker, for instance, being on both sides if they're individual agents who are representing the interests of their individual clients.
Yeah, as long as they're not talking to each other.
Right.
Well, as long as we trust them. Yeah. So it's like, you got to have a good relationship. With good relationships, it's okay. Yeah. That's why having a trusted realtor is critical for every, because realtors, as you all know, you have a million responsibilities, and the clients often don't know if you're doing your job or not.
True.
For example, yeah, you can set the listing price, you know, high so that you have less work to do, or you can set it low so you get more offers. Right. And the client's never going to know the difference. The client's going to follow your advice, like they follow my advice about half the time. Anyway, I want to be copied on all the documents you ask my clients to sign. Yeah, and I want, when the time is right, I want you to introduce me to the escrow officer, because the escrow officer is going to want several things from me. and every title company wants different things from me. And often escrow can't close for at least 20 days from acceptance. And so, keep in communication with me about what's going on.
Okay, so there's a good tip. So you've signed a listing agreement with your client. You're happy. You've asked them to provide you with the trust documents, which you will be sending over to your trusted, no pun intended, your trusted escrow officer and title officer. And then you'll be asking for the contact information of the trust attorney. And you'll be introducing yourself to the trust attorney and saying, we're opening a pre-escrow with these nice folks at this escrow company. And we'll keep you updated as we get closer to taking offers, et cetera. Are there any special terms that we need to consider? And John, that may be where you say, well, in this instance, we won't be able to close in less than, for instance, 20 days. So if you get an all cash offer that says 10 days, although that sounds great, we probably won't be able to comply.
Right. And mainly the realtor and the trust lawyer should be in communication from the beginning. And I want to kind of see documents before the client signs them. And buyers often think that, well, especially, buyers who will occupy the property, that they're not sophisticated and they make emotional decisions. So they often, generate the best offers as opposed to the rational investors. You have to handle the buyers who will occupy delicately because they're so freaked out and they're so emotionally involved in buying a home. Often, like, they think the personal property that they see in the house is part of the deal. So you need to exclude that as part of the deal in the documents.
So John, one of the questions in our Q&A here that I'm seeing is, often we have a scenario where the trust attorney is not available, dead, for instance, or the relationship between the clients and the trust attorney is no longer. Any advice there? Do we say to our clients, it would be best if you would contact another trust attorney and put me in contact to make sure that this runs smoothly? What would be your advice there?
Yeah, every trustee needs a lawyer. That's my short answer. Yeah,
and that's a good answer coming from an attorney.
Yeah, but I have a million disaster stories to back it up. We make most of our money cleaning up easily preventable disasters, right? And the title companies feel more comfortable if they're talking with a reputable trust lawyer.
Okay, why don't we jump into the slides and we'll get started and we'll let everybody understand the basics and we'll go from there.
Okay. Okay. A trust, I'm not gonna read every word or anything. I'm just gonna give you highlights.
Yeah.
A trust is a relationship. There are revocable trusts and irrevocable trusts. Actually, this doesn't look like quite the right slide, Dan, is it?
Well, it is the slide that we have, so let's go with it either
Okay.
way.
All right, I'm going to make a few corrections then.
Sure.
More technically, a trust is not a legal entity. It's a
Right,
relation.
so,
it's a relationship.
Exactly. In fact, I did that on purpose. So you see there, it says the popular lay definition.
Ah,
right?
yes. Okay.
Right. And so
Right.
the agents are always thinking that it's a thing, but it's
Right.
not a thing. It's a relationship.
Right. And a trust cannot own property. Only
Right.
that's what, yeah, the
Who
trustee
owns
can.
the property?
The trustee of the trust has to,
Right.
is the only one who can own or sell property.
Yeah.
Okay. And you didn't fool me, Dan. All right. So the living trust is also known as a revocable trust. And all it means is that it's the person who created the trust is known as the trust or settlor, normally. And settlor, it means the settlor is still alive, and the settlor can amend it or revoke it as long as they're alive and have their marbles. That's what a living trust is. That trust becomes irrevocable the day they die.
Which makes perfect sense, because the person who set it up, the trusting one, as they say, right, has decided this is the relationship they want. They have the option to change that relationship for a living trust or revocable trust at any time until they die, because clearly after they're dead, they can't change anything.
Right. And so the trust needs it's a new ball game on date of death. So everything changes on date of death. All the language of the trust is kind of frozen once and for all. Then it's just a matter of administering the trust to do whatever the trust document requires to be done. It's also possible to set up an irrevocable trust, like I could set one up during my lifetime. And usually that's done to get assets out of my name for tax or other planning purposes. Sometimes asset protection, like I could put assets into an irrevocable trust for the benefit of my kids. And if I get sued, those assets aren't mine. They're not available to creditors. So those are the two ways irrevocable trusts are created. Upon death of the settlor of a living trust and during the settler's lifetime by kind of gifting assets into a specially created irrevocable trust. There's a lot of different kinds of irrevocable trusts. I'm not going to get into that now, so maybe we can move on, Dan.
Okay, let's go to the next slide, Genevieve.
All right. In a lot of states, they use grantor or trustor. In California, it's settlor. They're all synonymous. The trusting one. And the trustee is the trusted one. The beneficiary is the lucky one.
Right, exactly. And so, you know, what's funny, John, is I've been all of these, right? So I have a trust where I'm the settlor, the trustor, right? I put the money in, my wife and I. I'm a trustee for my dad's trust, and I'm a beneficiary for my dad's trust.
Yep, that's common.
Yeah.
And the trustee has the heart. It's an impossible job to be trustee. It's easy to be beneficiary. All you have to do is attack the trustee and wait for your money to come. The trustee has a bullseye on their chest, and trustees are often sued because the parents haven't communicated what they're doing very well. And often the parents go to some bankruptcy lawyer to have a trust drafted, so the document's a disaster. Or they haven't looked at their trust document in 20 years, and so it's way out of date.
Or they move states, and they may not have accounted for what may need to be done in the new state.
Right. Or they forgot they had a trust, so they created a new one. Then we don't know which trust applies. There's all kinds of variations on the theme, but it's basically a lack of attention to planning that creates disasters more often than not. I mean, so the trustee has a vast responsibility to round up all the assets, transfer all the assets into their name as trustee, deal with the taxes, clean out the house, hire realtor, hire accountant, hire lawyer, deal with just every little detail, pay every little bill, deal with the beneficiaries who are calling every week asking, where's my money? It's a thankless job that can take years, usually a year and a half or 2 years ought to do it.
And it may, by the way, be a paid job. So you see the pronouns there next to trustee. I put he, she, it. And I guess to be politically correct, I should have also put they, because the it there is a reference to an entity. It's possible that there's a professional trustee who is not a family member, someone who's hired for this purpose.
Yes, and there, I think you're thinking of corporate trustees, Dan, like banks.
Right.
And banks are losing popularity as trustees because they're so ridiculously bureaucratic and risk adverse. And their primary duties are to their shareholders, not anyone, not any beneficiary. Anyway, banks are usually a bad choice, but sometimes they're a good choice for people with lots and lots of real estate all over the country, for example.
There are also attorneys who act as trustees who have, who are in the biz, so to speak, who have,
Yeah,
and I've seen accountants too, who do this professionally and just bill for it.
I think they're crazy. Yeah, partly because trustees, like in San Francisco courts, limit to trustee fees to like 150 an hour. And they can make more money being a CPA or a lawyer. Right. Plus, it's enough responsibility to be the lawyer. I would never think of being a trustee.
All right.
No. And there are professional trustees.
That's what I'm thinking of.
Yeah, those people can be a good choice.
Thank you.
And I work closely with them. They're called professional fiduciaries. They have a whole association. I often speak there. Anyway, and they often want their child to be the trustee, one of their children. And then
after the death, that trustee can give it up, right? The trustee can't be forced to be the trustee.
Actually, the distinction, Dan, is between trustees. Trustee is already acting in the office of trustee. Mm-hmm. The other option is named successor trustee.
Fair enough.
Which has not accepted the position yet.
Yeah.
And you're saying that they don't have to accept it, they can decline. And that's absolutely right. They can also resign as soon as their siblings start throwing bullets at them.
And that's what I was thinking.
And their siblings usually throw bullets at them because every childhood sibling rivalry is kind of coming to the surface because the authority figure just died and everybody's fighting to be king of the hill. That's the kind of the textbook situation of how it often works. Or maybe it always works, and some families are better at dealing with their internal conflicts than others, but most are pretty pathetic.
I appreciate that. Let's push us forward a little bit. This next concept here, avoiding probate, is somewhat of the obvious, but certainly needs to be stated. The main reason that most attorneys are suggesting a trust is for tax and or avoidance of probate matters. And so when I die with assets, they go into probate, meaning the state will administer the distribution of my assets. Whereas if I have a trust and I have moved my assets before death into that trust, meaning into the name of the trustee who's acting in this relationship, upon my death, those properties won't be probated. They will be administered by the trustee and distributed per the terms of my trust. Is that a fair statement?
It is, Dan. Yeah. And, before the pandemic, our San Francisco courts were broken. Now they're in a state of total collapse. And so the real purpose of having a trust is to avoid our collapsed court system. Particularly since with the changes in the estate tax law, the tax planning is usually not critical for people. I mean, you have to have more than about 24 million of assets to even think about estate planning these days, with state tax planning. Okay, so here's a summary. I'm not going to read them all, but it's basically privacy and avoiding probate. And trust can be used for additional purposes. And I think we can move on.
Okay.
Yeah.
And we talked about the first one, which is upon the death of the grantor settlor, this trust will become irrevocable because he or she can't change it any longer, right? And now we have a trustee needing to administer. And how do they administer? Pursuant to what does the trust say? You're going to give this to this beneficiary, you're going to give this to this beneficiary, et cetera, et cetera.
Right. And so someone has to contact me or an estate lawyer. Like I had a call this morning. I mean, the woman, her father just died, and the title is still in her great-grandmother's name to the real estate. So we have to work through several generations because they never had a lawyer before. And so it's going to be a big mess. But so this woman who called is the named successor of her father's trust. So she's going to accept the position of trustee. She's nominated to do it and she wants to do it. So I'm going to prepare a document for her to accept the position of office of trustee so that she'll be the trustee. Then she can sign our attorney-client agreement and your listing agreement. That's how it works.
Right. And now in the instance that you just gave where what frightened me was that the title is still in the name of a great-grandmother. Shouldn't that have been moved into the trustee's name long time ago? And wouldn't that property then be probated because it was never moved into the name of the trustee?
Well, ordinarily, a probate would be actually a probate of a great-grandmother's estate might be required here. We haven't really gotten into that far.
Okay.
And then a probate of grandma's estate might be necessary. Then a probate of dad's estate could be necessary. Although with that, if we have evidence that dad intended it to be in his trust, then we can use what's called the Hegstad petition to avoid the whole full-blown probate process. So we'll be working on this one for years to come.
Okay.
Yeah.
So how long does it, let's say my wife and I show up at your house, I'm sorry, your house. Well, maybe it is your house these days, at your office. And we say, hey, the Hershkowitzes are done. We never got a trust together. We'd like you to prepare a typical living trust. We have no children. It shouldn't be very complicated. We own 4 properties. How long is that process?
Well, I say, that's what they all say, Dan. It shouldn't be complicated. But I don't know who you're going to trust. And there's a lot I don't know. So I ask you some basic questions.
Sure.
And I also get a sense of like who you are.
Mm-hmm.
Paralegal Jennifer does the screening, and she'll rate your ability to listen to her. She'll rate your ability to follow instructions.
That's fine.
She'll, on a scale of 1 to 10, she'll tell me like whether she thinks you're a good fit for us.
That's hysterical.
And what your anxiety level is.
Okay.
And whether so then so I have the basic information, and then I talk to the client, to the potential client,
Mm-hmm.
and most of the time I agree with her, but not always.
Mm-hmm.
And then I'll end up saying to you,
Mm-hmm.
well, given your situation, Dan, given that I know you, and I know that you are organized and together, unlike some people, you know, we can do the whole thing for a fixed fee of X dollars. If you can complete the process within 12 weeks of our first meeting. And if you can't, then you have to renegotiate on an hourly basis with me.
Cool.
And there's several other conditions, like only 8 beneficiaries, and we have discussion as conversation, not in writing, not by email. And we limit the number of email exchanges.
Okay, so probably a little specific for us, but
right, yeah. But
what is that? Obviously, everybody's wondering what, in the simpler case where we feel good about the person, etc. It's not too complicated. What are we talking about for a fee? Is this a $10,000 fee or a $5,000 fee?
Oh, somewhere in the middle.
Okay, fine.
Yeah,
that's specific enough. Appreciate that. Now, the next question is, all right, we have established a living trust, right, which is a revocable trust, often called the Hershkowitz family trust. But we're trying, and then we're going to work to move all of our assets into the name of the trustee as opposed to my individual name. So my wife and I hold title here to the house as joint tenants with right of survivorship or whatever it might be, community property with right of survivorship. we're transferring the title into the name of the trustee. And if we're both co-trustees, it would be to our names, comma, trustee. And the title company will help us with that, right?
Sometimes, often we usually prepare the deed and we usually handle it.
Great.
Yeah.
Love
Yeah.
it.
And most residential properties purchase, well, there's an issue of, title insurance gets terminated upon transfer. So technically transferring it to yourself as trustee can terminate the title insurance policy. And so sometimes we get an endorsement from the title company for the trustees. And for transactions after about 2000, if you bought the property after about 2014, and it's a residential property, then transfer to trust is permissible. Anyway, we have to check all that out.
Okay, well, I appreciate that concept.
Yeah.
And just for the realtors out there, one of the things that's interesting about what he just said is the title insurance typically is also based on the purchase price. So if someone has not transferred the title in decades, sometimes when there is a title issue, the title insurance doesn't pay nearly as much as you think it does, because your clients paid $400,000 for the property 28 years ago.
Right. So for one client who bought the property in 1959, she's 92 now, we got an updated title policy for current market value.
Cool. Good for you.
Yeah.
All right. So what about a pour over? So some of the stuff that I own, I won't have transferred into the trust, or I bought more stuff and then I died unexpectedly before I was able to put it in to the trust, meaning transferred into the name of the trustee. So is that what this pour over trust is all about?
Actually, it's a pour over will, Dan.
Sorry, thank you.
Yeah. Okay. Yeah. So a will, pour over will. So typically when we estate lawyers prepare a trust, we prepare what's called a pour over will, which basically says anything not in my trust when I die goes to my trust after I die, so that all the assets get administered through the trust and go the way the trust says they should go. And if those assets are worth less than $166,000, then no probate is required. And we're not talking about retirement accounts or anything else with a beneficiary designation that automatically pass on death outside of probate in the first place. So it's things like cars or furniture or a small checking account or whatever.
Okay. Or what's in the safety deposit box? Seriously.
Right.
Right.
Yeah.
Okay. And here's one, and I think this is fun. What's a living will? So people think that, okay, we're talking about irrevocable trusts and we're talking pour over wills, and a living will, that must be some sort of a trust. And this is a little gotcha. And I'm going to give you the answer. A living will is not a living will. It's an advanced health directive. It's telling somebody if and when I'm in a vegetative state, pull the plug. It's all about medicine and what will be administered to me. So it doesn't really belong in this discussion, other than to say people often, the estate planning attorney will often, of course, prepare these for you, and healthcare directives and all that stuff, but it's not actually a will and it's not actually a trust.
Right.
All right, let's do the next slide. Where are we going next? Okay, so this I think is interesting, just to make sure people understand. Federal income tax ID number is actually the ID number of whom?
It's either a spouse if they're married.
Mm-hmm.
When I started my career, it was always the man's tax ID number.
Mm.
And there was always a man in a marriage.
Right.
And times have changed.
They have.
Thankfully, yes.
So it's the actual grantor or the settlor whose tax ID number is used, or two if there are two. It's not, or either, I guess, but it's not some new tax ID that's set up for some new entity. That's the point here, I think.
Right. So during the settlers' lifetimes, all trust income just gets reported on their 1040 as it was before they had a trust.
Right.
And But often when the first spouse dies, we get we divide the assets kind of between the decedent's assets and the survivor's assets, and sometimes the decedent's assets go into a separate trust created under their joint trust document, and that separate trust gets a separate tax ID number. But that's usually for kind of wealthier families or blended families where the spouse isn't going to inherit everything immediately. And when the survivor dies, then that irrevocable trust, also would get a new tax ID number ordinarily. And that irrevocable trust, so irrevocable trust, whether it's the decedent's irrevocable trust, the decedent spouses, or the survivors upon death, the irrevocable trusts are separate taxpayers. That's why they get separate tax ID numbers, and they have to file, trust income tax returns. Although there's a way to avoid filing the returns by reporting, actually not after they're dead. Sorry, take that back. Okay.
Why don't we go on to the next question, which a lot of the agents have, and I already saw in the Q&A a few times, is who signs on behalf of this trust? So the trust is established. Let's say it has co-trustees. Does the trust tell me if both trustees need to sign everything, or can one sign, or is that a matter of law, or is that what's designated in the trust? Does the trust decide?
They both have to sign unless the trust document says something else.
Okay, that's a great rule. So we're going to go with that. They both sign unless the trust document says something else. Now here's the next question. We get this all the time. Jim is the trustee and he's the only trustee, but he's granted a power of attorney to his cousin Sarah. Can she now sign? And what I always say is, well, most trusts are set up to say that the trustee cannot grant a power of attorney to a third person. So let's look at what the trust documents say. Is that true?
I want to back up a little before I answer. The probate code really limits the ability of the trustee to sign a power of attorney.
Good.
Like certain purposes are okay, like investing with a brokerage. You can delegate the investment authority to the broker. Mm-hmm. Selling real estate is not on the list as far as I can remember.
Great. Okay, so we should be dubious anytime that we have a trustee trying to sell real estate who says, I'm going to be out of town, but I'm granting a power of attorney to whomever to sign on my behalf. We need to be dubious there and talk to the title company.
Right. Okay. And the estate lawyer. Don't forget about us, Dan.
I do. Okay, great. Good point. Genevieve, let's see what the next slide is. So designating a trustee, that's completely up to the settlor, right? The one who creates the trust decides who the trustee is. And they also set up successor trustees. That's the backup trustee if the trustee is unable or unwilling to continue, right?
Exactly.
Okay. We talked about co-trustees.
We didn't talk about what a bad idea they are.
That was my next question. I was about to ask, do you have an opinion on whether or not co-trustees is a good or bad idea? And let me just give you an example. My parents have a family trust. I was designated as the trustee. My sister was designated as the successor trustee. And for those of you thinking that that was sexism, it isn't. She's the doctor in the family. She's in charge of all the medical stuff. I'm in charge of the legal stuff. But for a moment, they talked about co-trustees, and their estate planning attorney said that's a terrible idea because, tell us why, John.
Well, first, I think, I imagine you're very close to your sister. You'd be a great brother, Dan.
I appreciate that.
Okay. It's a bad idea because co-trustees rarely agree with each other, especially when they have a horse in the race. They're beneficiaries.
Right.
And they're kind of in a rivalry for who's in charge of the family now. And It's usually one of them's older than the other. It's just a mess. And it's a great way to run up legal fees, I can tell you that.
Okay.
And I never know who knows what or who's doing what, and everything's awkward. There's a million things that have to be reviewed, decided, and signed, and get two people in on every little thing. It just gets really crazy really quickly.
Okay, good.
And every now and then it works.
Right. Okay, but so we're gonna remember that, but we're also gonna remember for real estate purposes, if there are co-trustees, unless the trust specifically says otherwise, you need both to sign. So you need both of them on your listing agreement. You need to treat them the same. You can't go to one and not the other. All of your emails need to be copied to both, right?
Right.
So you're a fiduciary to both. Don't forget that.
Yeah,
right?
You're stuck in the middle. Yep.
Right. You're stuck in the middle. All right. All right. So what if the trustee is unable or unwilling to act? And I'll give you an example. My mother-in-law was the trustee for her brother's estate. After he died, she came to me with some questions, and it was obvious to me that she just, for her mental health, she should not take this on. And she resigned, and we gave this to a professional trustee. That's a possibility. The trustee can say, I'm not willing or I'm not able to act.
First of all, it was a very wise decision to protect her health, because I had a client who once died under the stress of being attacked as trustee. It's a very stressful job sometimes. So that was a wise move. And it all depends upon what the document says about who's next. And how does the next one get decided? Actually, this is a critical question. All the trustee provisions are the most neglected questions in all of estate planning. They're critically important, like who's going to be in charge? And who's going to decide that the settlor has lost their marbles and can't be trustee anymore? That's a huge one.
Yeah, I can imagine.
It used to be, the physician, but they don't even return calls about it. They're not trained to do it. They don't want to do it. And so we don't say the physician anymore. And often the clients will authorize a committee of people to decide that they themselves have lost their own marbles. Trusted loved ones, which might include children or siblings of the client, and
John, just to put a pin on this, this can be particularly important because most trusts start with one of the settlors as being the trustee. So the settlor is getting older. They are the trustee. They have named someone else to be the successor trustee after they have died, but it may be that their own capacity becomes an issue, right? And so the trust talks about having a committee decide when they're incapacitated and it should move on to the successor trustee. Is that right?
Yes. Yeah. And the committee can also can choose a successor trustee if that's how our client wants to set it up in the first place. Sometimes the client only has one or two people they want to trust as successor trustees. Then they want to give the committee the power to remove and replace trustees as they see fit. So that gets a lot of our attention in the planning process, and it should.
What about the limitations of the powers? So the trustee acts only as the trust documents tell them. Is that a fairly true, simple statement? So that trust document will say what property and then what they can do with it. Yeah. Yeah.
Subject to the limitations of the probate code. Right.
Yeah. What about a trust that says, and this was one of the questions in our Q&A, what about a trust that says there's certain real estate that's owned by as part of this trust, but we don't want it sold. We want an income stream, and the income stream shall go to the beneficiaries. If all of the beneficiaries collaborate and say, no, we'd prefer to sell and split the money, can they go against the wishes of the trust itself?
No, and not without court approval.
Okay.
And clients, often, they put a lot of hard work and sweat and made this wise investment for the family, and they don't want the kids to sell it and piss away the money.
Good. So deference is given in the court to their wishes that they set up in this trust.
Well, generally, but the courts are a little more liberal now than they used to be because of a recent change in the law about amending a trust like that.
Okay.
If circumstances change, like one of the kids really needed the money, then the court might, allow it.
Yeah. If all the beneficiaries agreed.
Right.
So if we were in this position as a realtor and the beneficiaries all wanted to sell the property, but the trust says otherwise, obviously we need to involve the estate attorney who's going to need to petition the court. Is that what's going to happen here?
Yeah, because the title company probably won't close escrow.
Right.
Because they want to see the trust document.
Right. Okay, good. And so one of the things the title company is going to do, it sounds like, is they're going to review the trust document to make sure that the trust document allows for the transfer of the real estate that's the subject of this escrow.
Right.
Okay, cool.
Yeah,
Right,
and even when the property is going to be distributed to the beneficiaries, which is sometimes the case, you want an escrow and title insurance for the beneficiaries. A lot of people skip that step.
Oh, tell me more about that.
Oh, the lawyer just distributes, prepares a deed transferring the inherited property from the trustee to the beneficiary, and the beneficiary takes title without title insurance.
Oops.
or an escrow. Yep.
Oh.
Yeah,
Okay.
saving a few $1,000. Yep.
Yeah. Penny wise, pound foolish.
Right.
Okay. What about this one? So we talked about a trustee and a successor trustee. We often have beneficiaries and successor beneficiaries or contingent beneficiaries. And let me just give what that example is. So my parents and their family trust named me and my sister, by the way, excluding my brother explicitly. Nobody's talked to him in 25 years. Total jerk. But anyhow, I digress. As the two beneficiaries, and everything was split between us. But then the question becomes, what if we predecease our parents? So if one of us predeceases, does everything go to the other? That may or may not be so. I can't remember how they set it up. Or if we both predecease our parents, then are there contingent beneficiaries? And between us, I don't want my wife to hear this. This is hysterical. So we're trying to figure out who the contingent beneficiary should be. And we're throwing out all these names. Oh, what about this family friend and that cousin and blah, blah, blah. And it was like 10 minutes later, I'm like, oh, Elisa, I forgot my wife. I think she should be a contingent beneficiary. And my parents were like, oh, yeah. Oops.
Right.
Right.
Nice catch, Dan.
Yeah, right.
Yeah, and often they don't want the spouse to have anything.
Oh, good point.
Often we work hard to draft it so the spouse can never inherit it because they don't like the spouse often. So the spouse can never inherit it. So Sonny has to have a prenuptial agreement that, spouse is not going to get it.
Cool. Fortunately, that's not the case here. So also as a viable contingent beneficiary, we often see charities. Yes.
Yes.
Okay. All right, cool. And sometimes we'll often see charities as a primary beneficiary, right? The estate is split in thirds, and I'm sorry, it wouldn't be the estate, but the assets are split in third, and a third will go to a charity.
Yeah, but unless you have, more than 24 million for a married couple or 12 million for a single person, it's way better tax planning to give to charity while you're alive, because then you get an income tax deduction. If the charity's inherited, there's zero tax deduction of any kind. Okay.
Though you might want to hold on to your money and you're only willing to give it to the charity after you're dead and you don't want it, you don't need it anymore.
That's kind of the conflicts our clients have to face.
Right.
Yeah.
Like I love NPR, but I want my money right now, and I'm more inclined to give it to them later. Right.
Right. Yeah, and sometimes giving to charity through a retirement account is more tax efficient.
And this next question here is what can be given away in a trust? And so I think that's somewhat, self-evident, but it's the assets that are owned by the trust or settlor that they then move into the trust and that are named in the trust, right?
Right. In other words, Dan, you can only give away what you own. So the first question is, what do you own?
Yeah.
And a lot of people don't know. Like they forget that the real estate's held in great grandmother's name, or they forget, they just don't know. They forget that they even have a trust.
Yeah.
They don't need, I mean, I've been their lawyer for months or years and they forget my name. So, so that's why we always want to see documents. We don't believe a word people tell us. We got to see the documents. We get the, the vesting documents from the title company. Even the most recent vesting document, you can't rely on it, particularly if a title company was not involved. So you have to sometimes trace the chain of title to see if it even looks like it was done right. So it's a lot of work to figure out what they own. And with marital property, it's even messier because there's community and separate property, and often spouses kind of get it all mixed up and you can't really sort out what's separate and what community. And there's different tax consequences for sale of separate and community property. Often people with separate property have a separate trust. And if they have community property, they also have a community property trust. So a spouse could have, two spouses, they could each have a separate property trust, and they could have community property trust, 3 trusts for one couple, along with, a property agreement to start out with, to just clarify, which spouse owns what.
Appreciate that. All right, let's see what the next one is. Oh yeah, so this is, you mentioned this earlier. So sometimes I have assets, like something in my Morgan Stanley account that has already a death beneficiary named. So do we move these into the trust, or they're already taken care of?
They're already taken care of, Dan. They pass automatically outside of probate anyway. And so ordinarily you would just name the individuals, with Morgan Stanley that you want to get it when you die.
Okay, great, appreciate that. And we have that, there's actually a new deed for passing real estate on death, something on death deed that came out about 5 years ago, and that was recently renewed by the legislature.
Transfer on death deed.
Yeah, not used very often though.
Right, it's been a bad idea from the beginning.
Okay, so let's not talk more about it then.
Yeah, I've never done one, and I don't want to do one.
Okay.
There's too many unanswered questions about them.
Okay. All right. And so this one is just sort of a lawyerly question. Can a trust acquire and convey interest in real property? And it says technically no. And the reason it says technically no is the trust is not really an entity, it's a relationship. And so it's the trustee, right? So it's Daniel Hershkowitz, trustee of the Hershkowitz Family Trust of 2022, who really is acquiring and conveying the property.
Right.
Okay. All right. What about title company requirements? Why do we have this slide? What does the title company need to know? What's this certification of trust all about?
It's an affidavit that the trustee signs that basically says this trust has not been revoked or amended. I'm the current acting trustee of the trust. I've got the power to sell the asset under the trust document. Please let me sell the asset. Signed under penalty of perjury and notarized. So the title company wants that. Often they prepare them.
Okay.
Yeah, and there's other things the title company wants. Often they want a letter from me saying that the trustee is still the trustee, that all the taxes have been paid for, have been paid, and no objections to the proposed sale have been received. Sometimes they want other things. You just never know.
Okay. All right, what else do we have? Genevieve, what's next? Oh, here we are. Assets with trustees and the power of attorney. We talked about that. transferring assets to the trust or trustee. Well, that's an interesting one. So you've helped us set up the trust. Do you, as a good estate planning attorney, help us figure out how to transfer the assets? Because what I could see happen often is we have a trust, but then we do nothing to actually transfer the assets.
Well, that's the kind of trust you get. If you open up the Examiner, you can get a trust for, $700. You get a trust, but no, you don't get any help like transferring the assets to it. So a lot of people selling cheap trusts, which generate a lot of work for us. But in any event, yeah, we're very thorough about that. Usually we handle the real estate transfers, and we give the clients instructions about how to deal with their stocks and investment accounts to themselves as trustee after they sign the trust document.
Excellent. All right. So you know what I'm thinking, because of time, maybe we're technically over. Why don't we open it up for some questions and see where that goes? And we'll give that about 10, 15 minutes, and then we'll say thank you to everyone. Who would like to talk? Or maybe we did such a good job, John.
Maybe everybody's like technologically silenced.
Oh, that's interesting. Genevieve, can they in fact talk if they wanted to?
No, I would have, if they raise their hands, I would have to let them in the chat to talk.
Okay, so is there anybody who does have a question who would like to raise their hand? You can go to the bottom of the screen, find the raise the hand function, and give it a shot. All right, how about this, John? Is there something that we screwed up or didn't cover that we should, is burning desire? Or do we feel pretty good that we put them on the right path?
I feel good that we gave a good general overview.
Great. I'm feeling good too, but of course I'm biased in this. Diane, is there anything you think that we screwed up that you'd like us to go back and fix?
Hi, thank you. I'm here. I noticed that there are a few questions in the Q&A, and I wonder if there's time to take a look at any of them.
Yeah, let's do that. We'll put you in charge. And look, your cool dog. Hi, dog.
We also have a few hands raised as well.
Okay, so let's start with the hands, and then Diane will help us with the questions. Diane, we're going to put you and John in charge of this section here. I'm going to be quiet and mute myself.
Okay, first question from Meredith Martin.
Oh, hi. I'm just curious if there's anything like broad level. Obviously, everything's different, but are there any broad level things that people that own properties in multiple states should know in terms of creating a trust in California versus, I'm dealing with people that have properties in Incline Village and that kind of thing. Is there anything that jumps out at you, or is it just a specific case by case thing?
Well, normally, Meredith, the trust is created under law where the person lives, the state of where they reside most of the time. And then for out-of-state real estate, like if it's a California resident with real estate in Nevada, then a California lawyer can't prepare the deed. A lawyer in Nevada has to. So that's how that works. Yep. Does that answer your question?
It does. If I'm not sure if I'm hoping to be muted again in a second. It definitely answers my question. And then would it be the trust attorney, aka you, that would refer them to a Nevada?
Yes. Yes.
Thank you. That's it.
Thank you, Meredith.
Next question is from Amanda Jones.
All right, and everyone's invited to contact me or Dan if you have questions anytime. Amanda?
Thank you. So my question, over the years, I've had a lot of transactions with families, and it was really interesting to me to learn from you that the trustees really get beat up. I haven't had any of those yet, but I want to do more of this work because I really enjoy helping people move through things. And I'm somebody who spends a lot of time with my clients, just you know, I'm not like a churn and burn type agent. Like I really like to spend time, and fixing up houses to sale is something that I also really like to do. So my question, and maybe this will benefit other people, is if I wanted to kind of learn more and also try to attract more of this business, do you have any thoughts around that? Trade organizations or ways that I could kind of get into this environment? Because I think it's very gratifying work.
It is incredibly gratifying. I can assure you of that, Amanda. Yes, or I can agree with you on that. Yes. Let's see. It's an older client base normally, because the real estate usually gets sold upon the death, and because the beneficiaries usually prefer cash rather than real estate for some reason. And so about 90% of the real estate gets sold upon death. And so kind of your target audience is probably those older property owners. And there's various organizations like the San Francisco Apartment Association that is full of older owners of San Francisco rental properties. And you could get involved there. That's one idea. There's also the Small Property Owners Association. I speak to both those organizations. There's the Professional Fiduciary Association, which we mentioned earlier. There's estate lawyers. You know, we have salespeople kind of calling us all the time, so you really need an introduction rather than calling us out of the blue, probably. And I can introduce you to some if you contact me. Because I know some of the newer estate lawyers, and so I just know a lot of estate lawyers. Those are some ideas. But you can also learn, we have a newsletter that goes out every several weeks about the colorful appellate cases and celebrity cases. It's very popular. So you can educate yourself that way. One of our headlines was Martin Luther King. He had a dream, but not a will.
Yeah. That's very funny.
Yeah. So we have a lot of fun.
Okay, let's see what else. Who else has a question? Thank you, Amanda.
Donna Crowder.
This is like the greatest hits of realtors with questions. I know these people.
Donna?
Hi. I had, and I'm not sure we have your contact information, but at any rate, I also had a cross-state question about trusts, but it's at the end of the trust after the person is deceased, and let's say the estate's being dispersed or retitled. Let's say the person lives in one state and the trust is initiated in one state, and then they get the second state attorney to title the property correctly into the trust. So everything's titled correctly into the trust. When they decease, the trust in their home state is the one that prevails even in the other state? Or what if they move back to the other state? Does the home state, does the California trust still prevail? Just questions around that.
It's a very good question, Donna. Thank you. And as usual, it depends upon what the trust document says. Most trust documents created in California just say California law is going to apply, period. So it doesn't matter where they move to. But it is possible to allow for flexibility and say the law of the state of residence of the settlor applies. Or sometimes it's the law of the state of residence of the trustee. and every state has different laws, of course. But if they're going to move like to some other state, they really ought to get the trust redone in that state. So it applies under that state's law, and they use the lawyer in that state, and they're kind of done with California.
You know, John, we did that recently. My parents moved them from Florida to Washington State. And so I made an appointment with the local Washington State estate planning attorney. And he said, because of the amount of the estate for my parents and the $2.5 million, blah, 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 that was of Washington, he said, frankly, the only thing I would update is, and then he suggested that we update the medical directive stuff, because he felt as though a doctor seeing something from out of state may not react to it. He wanted them to see the what they're used to seeing for the locality. But other than that, in that instance, he said, you're fine, you don't need to redo anything.
Yes, that sometimes there are reasons like that. So it takes some thought.
John, can I ask a question real quick? Sometimes we have a trust that says upon the death of the trustor, beneficiary Sarah will get the real property, the house at 123 Main Street. And then the house is in fact distributed to her. And now she comes to a realtor and she wants to sell it. That's not a probate sale. That's not a trust sale. The property has been distributed to her. She owns that herself. And she's just transferring title like any other individual owner. Is that correct?
Yes, as long as, you know, only her name appears on the deed as an individual.
Right.
And the transfer was, and she has clear title, yeah.
Right. Okay. And so sometimes I have agents who call me and I say to them, no, look at the title. It should be as her as an individual. The fact that she got it, you know, last week through this process doesn't mean that it isn't hers. That doesn't mean that all the rules and laws don't apply for her transfer. There are no exemptions like for a trust sale.
Right. As I tried to indicate earlier, Dan, you know, be leery of any deed prepared by a lawyer and not a title company.
Appreciate that.
Out of the trust, yeah.
Diane, what are we missing? We'll try to hit a couple of those and then we'll wrap it up.
There's quite a few questions. I wonder, there's one that I think perhaps Dan or maybe Genevieve, you could answer. There was a question out there about whether the slide deck can be distributed via email.
So we do post, Genevieve, you'd have to answer that, but I do know that we have a YouTube channel for San Francisco Association of Realtors where we post these videos. And I think there are links to slides there as well. Is that right, Jen?
Yeah, I can add the link to the slides when we post on our YouTube channel.
Great. Okay. There are quite a few questions. I wonder if I can just try to move through them quickly. One of the questions here is about investment property and whether, let's see, this is a case of clients who have their home in a trust, but not their investment property.
What's the question?
The question is there an issue for not putting the investment property into a trust?
And the answer is, yeah, the investment property is going to have to go through the collapsed court system.
The probate.
Probate. And the purpose of the trust, which is to avoid probate, will be defeated.
At least with regards to the assets that are not moved into the trust ownership, right? So that's the same issue as you went and got a trust online, but you didn't move any of your assets into the trust, right? What's the point?
Right.
It's an incomplete process.
Okay, cool. What's next?
Next, I see a question from Norman. If an irrevocable trust stipulates property can never be sold, is it possible for the trustee in the future to sell when circumstances change?
And not to shortcut it, but that was our discussion John and I had, where the beneficiaries say, no, I don't want the income stream. I want a big lump sum of cash. You'd have to petition the court, and the court would have to be convinced that the circumstances have changed enough to warrant this.
What a bad idea to say the real estate can never be sold. Like what an enormous disaster that is.
Okay.
Because those realtors are hungry.
Right.
To be avoided. Okay, Rosario asks, it says, I heard that in order to avoid high estate tax, we can buy insurance and use this insurance to set up an irrevocable trust. But if there already is a revocable trust set up, will it be affected by the irrevocable trust being set up?
Well,
John, do you have any idea what he's talking about?
the revocable trust, it needs to be coordinated with the irrevocable trust for the life insurance. I think it's a question about life insurance
It's a whole life concept.
generally, or often universal life. But in any event, there's a special way we do trusts for life insurance. So it needs to be a very particular kind of irrevocable trust. It needs to be coordinated with the revocable trust. But it's only makes sense for individuals who are planning to die with more than 12 million, 24 million for a couple under current law.
I'm planning on it, but it's not looking that way.
Yeah.
There's still time.
Yeah.
Okay, next question is from Carolyn. The question is, when using the San Francisco seller disclosure in a trust sale, is the successor trustee also required to include the exempt seller disclosure?
Okay, so this is very specific for me.
Very specific.
Right, the answer is no. So what's unique about the San Francisco purchase agreement, it says even in an exempt transaction, the seller, whomever it is, will be providing this supplement to the TDS called the San Francisco Seller Disclosure. And it has 3 boxes: yes, no, don't know. And so the don't know box should make your person who doesn't know a lot feel good. But you have to still fill it out. The first page has the exempt seller disclosure questions embedded in it. So you don't need both. It would be duplicative. Okay.
Thank you. We have another question from Jay Mario. When a trust exists and the successor trustee accepts the duties, is it still a requisite to hire an attorney for the remainder of the process to achieve a sale? And if so, are you accepting new clients?
Yes and yes.
Okay. Excellent. Norman asks, if I get paid for a trustee fee, is the expense considered a business income to avoid paying self-employment tax?
If you're in the business of being a trustee, it's subject to self-employment tax. If this is like, if you're only trustee for one trust and you don't do it all the time, it's not subject to self-employment tax.
Okay, thank you.
And a lot of family member trustees, by the way, waive their right to compensation to avoid the need to pay income tax on it. So the family gets more money, the beneficiaries get more instead of the government.
Okay. Diane asks, exactly how does the client fund the trust?
Well, we talked about that a little bit. Depends upon what kind of assets there are. I mean, there's special deals, special way to handle cryptocurrency, a special way to handle, personal property, the stuff in the house. And real estate requires deeds. Every asset has a different kind of transfer mechanism. And you then need to use the right mechanism to transfer that particular kind of asset to the trustees of the trust.
Mm-hmm.
And the lawyer normally guides the process. That's why it's kind of what we do.
Okay. Norman asks, does an irrevocable trust last forever? And if beneficiaries die and it goes to their heirs, it's a comment. There can be many, many beneficiaries. So the question about the scope and length.
Yeah, like my grandmother has, 55 descendants living. If she had that trust, the real estate should never be sold. They'd be distributing income to 55 different people every year or every quarter. Be like a nightmare. Plus, you need income tax returns every year. and a trustee services every year, and the trustee needs a lawyer every year. It's just all that expense in perpetuity. It's like crazy. And more specifically, irrevocable trusts, every trust should have an end date. There's no, like people have big egos, so they don't want the real estate ever to be sold. So that person got bad advice. So typically the trust terminates, when the grandchildren die, or usually I can convince them that the trust should terminate, when their own kids die, or when their grandchildren die, where the real estate can't be sold for 10 years, usually, or 20 years. Usually that's enough to satisfy their egos.
Okay, so limitations are the right thing to do.
Yeah.
Norman asks, are trusts recorded in county?
Trusts are not recorded.
I think that's a good point right there. The trust itself is not recorded. And so what's interesting, and you'll learn when you go to a trust attorney, is what happens when you die, Mr. Trust Attorney, right? You have an original. Do I have an original? Are there 3 originals? And you'll see that depending on the state, there's specific requirements that, for instance, in Florida, the trust attorneys have to register their clients and provide some mechanism for, fireproof safes, et cetera, and have other attorneys who have access to them in the event of their death or incapacity. It's interesting.
Yes, and every state does their laws differently. And here, the trust doesn't get registered or filed anywhere. It's a very private document. That's one of the benefits of having it from a trust as opposed to a probate. With a probate, all your personal and financial information becomes public. With a trust, it's all private. And it used to be that we, trust and estate lawyers, would keep the signed originals in a big safe, but not anymore. In the last 25 years, the whole norm has shifted. So now we give the signed originals to the client. So the client keeps them and stores them.
Okay. Thank
And
you.
then there's a discussion about where they ought to keep them, which is kind of a separate topic.
Okay, thank you. Margaret asks, if the named beneficiaries are minors, how is that handled?
Usually, our standard approach is the money gets held in trust for them until they reach a certain age. Most people choose 25, and the trustee has discretion to give money to them sooner for living expenses or education or certain other purposes.
So there's a second trust that is established if, when it comes time to distribute the money to a beneficiary, if that beneficiary is a minor, often you'll set up a separate trust. But if the trustor lives long enough that they become of a certain age, it becomes a moot point.
Right. It's all in one trust document, Dan. But
okay, thank you.
Yeah.
The
And
trust
there's
within the trust.
Yeah, there's also a problem like with naming minor beneficiaries on a retirement account or something, because ordinarily someone would have to go to court to be appointed their guardian of their money, which is a huge headache. And under the new Secure Act, we have provisions in our trust document that allow for the trust to be named as a beneficiary of the retirement account for the minor people, to avoid some of the complications of the past and doing it that way. That's the big picture on that. But most lawyers are not even up to date on what that means or what that is, or what I just said.
Thank you. A few more questions. Ivan asks, what happens when a life estate owner becomes incompetent, but a county refuses to follow the trustee's instruction to sell the property to benefit the life estate holder for medical care.
Talk about a specific question.
Well, the county refuses. What's the county got to do with it? I don't get the question. County doesn't usually have authority about selling a property or not.
So I think that one we're going to need to have your clients address to their specific state attorney.
Yeah, or contact me privately.
Yeah, which there's another question that might help. I mean, there is a question up there about your contact info, John, and whether there'll be a slide or if your contact info is available for folks who want to follow up with you.
Well, it's o'gradylaw.com, OGRADYLAW.com. And it's John with an H at o'gradylaw.com.
Okay.
Email. Yeah.
Thank you. A couple more specific questions. Mary asks, do I need to move mutual funds / retirement accounts to my trust? Usually that's beneficiary. There's a designated beneficiary. So I think she's asking for clarification.
Retirement accounts don't go into the trust at all.
Okay. And then we have an anonymous question. If the trust has co-beneficiaries / trustees, are the taxes paid equally or individually by the co-beneficiaries / trustees?
Well, the way it normally works is the trustee files a trust income tax return and gets a deduction for amounts distributed. So if the trustee distributes the income to the beneficiaries, there's a deduction for it, and the trustee doesn't pay the income tax on it. The beneficiaries do on their 1040s.
All right, we're going to wrap it up. You know why? Because my wife is yelling at me. We're on
It's time. I have one last question that I think is just the global question, which is this recorded and will it be available for later access?
Yeah, so Genevieve, we do have a YouTube channel, San Francisco Association of Realtors YouTube channel. If you go to YouTube and search for SFAR, San Francisco Association of Realtors, you'll find our YouTube channel where this will be recorded. Probably will show up there in a few days.
Fabulous. What fun.
Right.
Thank you, Dan.
I
Thank
think
you,
we did it.
everyone. Yeah,
Thank you
great
to
questions.
John and Diane and to
Thank you, Dan.
Genevieve and to all of
Thank
you
you,
nice
John.
people.
Yes.
All
It's a
right.
pleasure.
As always, I am grateful to have this job and to be with you nice people, and grateful to work with such smart agents. We will see you next time, and we are declaring this a success.
Yes.
Bye, everyone.
Thanks, Dan.
Thank you.
Bye for now.
Bye.